Yesterday, Joe Biden gave a speech where he announced 3 major reforms, which is not quite the right word because, well, I guess it is. I guess it is reforming a thing. But reforming implies that it's broken and needs to be fixed. But 3 reforms to the Supreme Court. And I want to talk to Ken Klukowski about those said reforms. Ken, how are you, sir?
Good morning, Mike. How are you?
Good. I'd like to address each of these on their merit if we can find time for it. The one I find most intriguing is term limits. So the suggestion is, the proposal is, that justices should serve 18-year terms. So every 2 years, there will be a vacancy that the president would be able to fill. Why did our founding fathers not do it that way? They've heard of term limits before. So why did they not put term limits in the first place?
Well, in fact, I think let's start off with the vocabulary. Rather than saying that this is a proposal to reform the Supreme Court, I'd say it's a proposal to transform the Supreme Court. That's like you write a paper, you take it into your teacher, for edits. And the way she edits it is by throwing it in the trash in front of you and rewriting it from scratch. Someone could say, well, you have now edited my paper. And so, well, edited, kind of suggests limits, that kind of small scale. That's why I look at reforms, as opposed to you have totally now changed this. It's to taking that global thing and then going to the specific point that you mentioned. One of the hallmarks of a free society, this is the answer to your question on term limits, is like when I was when I was working on one of my first Supreme Court cases, McDonald v. Chicago, 2010. This is coming off the 2008 case, D.C. versus Heller, that held the Second Amendment is an individual right for private citizens to keep and bear arms, that it was a right held by citizens, just like the First Amendment and the Fourth Amendment and everything else, and pretty much everything else in the Bill of Rights. And then the question immediately afterwards was, hang on a second, does the Second Amendment, the Bill of Rights only gives you rights directly against the federal government. Does this also apply against state and local governments, which is done by the 14th Amendment? And when that was being argued in front of the Supreme Court, the challenge we had was this. It was, well, look at Japan. Japan is a free society. Everyone acknowledges Japan is a free society. But gun ownership is virtually forbidden in Japan. So it was, as people were talking about what sort of rights are so fundamental that they extend against all levels of government, it was, well, if Japan's a free society and people don't own guns there, then how can you say, using language from old Supreme Court cases, that the right to keep and bear arms is like implicit in the concept of ordered liberty? And so it's in the Supreme Court squared that knot by saying there can be different visions of liberty. For us, a right in the Bill of Rights is fundamental if it is essential, if history and tradition reveal it's essential to an Anglo-American scheme of ordered liberty, to our concept of a free society. So even things as fundamental as gun ownership are not a feature of every free society on earth. But let me tell you one thing that is, an independent court system, a judiciary that is immune from political pressure, that is sheltered from the elected branches of government and the people who control the guns and the handcuffs, the executive, that a court system that does not answer, that is co-equal in power to the other branches of government, that is an essential cornerstone of a free society. And that is why the Constitution gives federal judges at every level, including the Supreme Court, lifetime tenure, and also that their pay and benefits cannot be reduced. It's to ensure that those who hold the other levers of power, whether it's Congress, which holds the power of the purse, the money, or the executive, which has the guns and the prisons, it's to ensure that judges can stand for people's rights, even when there is a mob-like mentality that, a fever that's going on in the political circles that would otherwise trample one of the rights of the people.
How would putting having a 18-year max on a term and putting a new one in every 2 years, therefore, how would that decrease their what's the word? Not individuality. What's the word you say?
Their independence.
Independence.
It could be done, but only by a constitutional amendment. The American people do have the power to being the source of power that created the Supreme Court to begin with. The American people do have the power to decide, okay, we're going to go from lifetime appointments to also just saying it's going to be an 18-year term, and every 2 years there's going to be another one, and therefore we know that every 2 years, whoever the president is, we'll know that when we're electing a president, we're also electing, someone who will make 2 Supreme Court appointments. The American people could do that, but it would have to be done by constitutional amendment, because the Constitution says that federal judges, including the Supreme Court justices, hold their offices during good behavior, which ever since the Constitution was ratified in 1789, that's been understood to mean you have to be convicted of a felony. So you have to be held guilty by a jury, found guilty of a serious crime against society, that's what it means to not be in good behavior. That for anything short of that, a federal judge can serve as long as they want, until they either retire or, as some do, ultimately die in office. So these proposed reforms, maybe they could be done, but only the American people could do it. No president in Congress can do it by themselves.
So a Congress can't even impeach or remove a Supreme Court justice?
They can by, remember, when it's a president, you impeach and remove for treason, bribery, and other high crimes and misdemeanors. For a federal judge, including the Supreme Court justice, you impeach and remove for them no longer showing good behavior, meaning ever since 1789, the sole reason that, like Alcee Hastings, a federal judge in Florida who got convicted of taking a bribe, after which he then got elected to be a Democrat congressman, because evidently in the modern Democrat Party, that's like a job qualification. Oh, you got convicted of a bribe. You should meet Joe Biden and Kamala Harris. They're going to love you. But Alcee Hastings, that's how he ended up in Congress. He was a federal judge. Then he got convicted of taking a bribe in a case. And so he was impeached by the House and removed by the U.S. Senate because he was no longer showed good behavior.
Very good. Okay, so my question was, how does it decrease independence of the court? And you answered perfectly on, literally, how would we make this change that Biden proposed? And it would require a constitutional amendment. My question, to be more clear, is your first argument was lifetime appointments allow for more independence. And my question is, well, why is that so? Why would, if we did institute 18-year terms, how would that decrease the court's independence?
Well, it's because it would still show for a Supreme Court justice, like take Clarence Thomas. I'm 48 years old. Clarence Thomas got confirmed to the Supreme Court when he was 43. 5 years younger. All of a sudden I feel like I'm an underachiever in life. Clarence Thomas, 43 years old, an 18-year term. Well, that would mean he would know that at age 61, he's not going to have a job. At age 61, he's going to need to be looking for another job. So he's going to be thinking in terms of what are my career prospects? Who do I? It could well be that he's like, look, I have a God-given duty, and I swore an oath before God to serve this country, and I'm going to do so faithfully for 18 years, and I'll just figure out what job I'm going to have. At that point, a person could do that. But the framers wanted to insulate them from that pressure, to be like, you know what, you never need to worry about a job for the rest of your life. This is your job. And don't let any external pressure, financial concern, career concern, political concern, don't let any of that ever get in the way, so that you don't have to think in terms of, like with Harvard racial preferences, to be like, you know, what Harvard is doing here violates federal law. I need to hold that it's violating federal law. Well, if you're someone and says like Clarence Thomas, take you know, a white person like Neil Gorsuch or Sam Alito, to be like, well, if I render that ruling, are people going to call me a racist? And then it's going to be harder for me to find a job later on in life. The framers just wanted them to maximize their freedom, to maximize their confidence, to be able to say, you know what, my duty to my country before God is just to apply the law to the facts and not to worry about anything else. And
Great point. Okay, we got two minutes. 2 minutes. What other of the three transformations do you think is
well,
the worst?
The ethics code, that is clearly an attempt to hamstring Supreme Court justices and make the institution of the Supreme Court subordinate to Congress. You know, the Supreme Court cannot vote to adopt an ethics code that they can apply to members of Congress, all right, or to the executive. But here, they're looking to create this ethics code that would say, well, if you do this or that, you have to recuse yourself from a case. And we know the way that the left works. This code would be structured in such a way that if you happen to be a conservative justice, maybe a justice who has voted pro-life, or a justice who likes to go hunting, or whatever, that all of a sudden you're being recused from key cases. This is reverse court packing. Versus, I mean, as I've said before, you know, with retired Justice Stephen Breyer, or with the late Justice Ruth Bader Ginsburg. You know, Stephen Breyer took like 233 paid trips, you know, put on by billionaires and stuff. People like Illinois Governor Pritzker, you know, from that guy. That's a billionaire family, and they've got a private jet and stuff. And you know, they take justices around the world on all these junkets and stuff like that. Now, no one ever claimed that influenced Justice Breyer's vote or Justice Ginsburg's vote. It didn't. But those things weren't even called ethics scandals. You see here in Kamala Harris where she's like, oh, there's all these ethics violations going on. That's what she put out yesterday, endorsing this attempt to take over the court and destroy its independence. Liberal justices have been doing that for decades. No one had any problem with it. So that's
and not only the justices, Leonard Leo, in short, said, okay, we'll talk about this ethics reform with the court, but first apply it to the Democrats and everyone in Congress. Right. And then we'll chat after that. The great Ken Klukowski, our legal analyst at Breitbart, and article with all this in more detail on Breitbart.com right now.